Hi folks, you're with Tacitus Today at your Pushback channel. While you're with us, please take a moment to subscribe below. There have been some great and significant miscarriages of jurisprudence throughout history, and the legal system has typically learned some significant lessons in retrospect from which key legal reforms have later emerged. In total aggregation, these legal reforms and the accumulated knowledge and understanding acquired over 1,000 years represent the sum total of our legal knowledge today. Are we now in danger of throwing it all away in an act of monumental folly? The subject of this essay considers the question, is Western society and Western jurisprudence, as it is being forcefully transformed from sovereign national jurisdiction law to globalist politicised law, is the West abandoning millennia of acquired legal practice, theory and application? Those who do not understand the mistakes of the past are doomed to repeat them. So are the newly minted Western sociology SJW law students of recent times being trained, primed, inveigled and slogan impregnated to tear down the rule of law and due legal process that, if continued, will most surely play out into anarchy, the ramifications of which may very well lead to the Western polities on a short route to disaster. Amongst the big legal jurisprudence shaping milestones of history, we can include the Spanish Inquisition, McCarthyism, the witch or demon trials, regicide and the separation of powers, and of course habeas corpus. Of these great issues of legal history, I was stunned that not only are none of these major legal collision points of history not taught in the law courses or modules we could find, but the students I spoke to knew nothing about them, and when given a short overview, dismissed such issues as irrelevant. The damn gender wage gap and gender pronoun usage is by far a bigger issue than any of these things, and is way more important. What? These low IQ law students are readily prepared to dispense with and to ignore the entire history of Western jurisprudence, and are encouraged to do so by the academic elites. These are big lessons in jurisprudence, and they're learnt the hard way, often with much shameful blood and intense retrospective regret. So let's do a quick run through. What are these big issues? What are their implications? And are they in danger of being lost today? The separation of powers between executive government and the judiciary. In January 1649, after years of civil war, the British Parliament put the English king on trial. The king was simply declared guilty by the equivalent of the Prime Minister and his senior ministers, in effect a Star Chamber. The king was not permitted legal counsel and was not permitted to question those witnesses brought against him. The king had not entered a plea, but was assumed and asserted as guilty regardless. The king didn't help his own case by refusing to accept the authority of the Parliament, but nonetheless. The subsequent shockwaves, due not only to the act of regicide, that is the killing of the king, but to the employment of arbitrary executive power, led up to a series of law reforms known as the English Bill of Rights and the Act of Settlement in 1701. These laws and traditions were passed on to the American colonies and to Canada and to Australia. In short, these reforms placed all citizens as subject to the law. None were above the law. The state could no longer simply assert the guilt of the accused, and the accused had the right to question witnesses, and importantly, the executive, the legislative and judiciary were viewed as separate arms of government, each to be a check and balance over the other. Further reforms would come. Habeas corpus, for example, preceded these events, but this was perhaps the most significant 20 years of legal reforms witnessed in the Western world, and in so doing significantly, if not pivotably, changed the face of Western jurisprudence. In 1679, Britain, the parliaments were concerned that a monarch or the executive still had the effective power to arbitrarily arrest and to detain a citizen, without demonstrating reasonable cause or laying specific charges, and without the setting of a timely court hearing date. This was particularly represented by the concerns over the acts of the Catholic James II in chasing down Protestants and Protestant sympathisers. Upon serving a writ of habeas corpus, the detainer must bring the detained to an independent court where the lawfulness of their detention based on evidence can be determined by a judge or magistrate. Technically, habeas corpus had existed since the Magna Carta and had been reaffirmed again in 1640, but these were deemed as administratively incomplete and in contradiction with other laws and statutes. The 1679 writ of habeas corpus strengthened and clarified the language and codification. Further modernity-type amendments were made to habeas corpus through the early and mid-1800s. Spanish Inquisition. Now, put in simple terms, the Roman Greek principles of law merged into religious church or Catholic canon law as practiced across most of medieval Western Europe. As most magistrates and prosecutors were clerics, canon law became the de facto law standard. Following mid-1500s England and the northern Germanic states of Europe and the establishment of the Protestant, Lutheran and Anglican churches, Catholic canon law gradually gave way to what today we would call common law or case precedent law. The Spanish Inquisition was launched in a time before the Age of Enlightenment, and it was still widely believed that demonic possession, witchcraft and the devil's henchmen were everywhere to be seen, seeking to lure upstanding, God-fearing folks from the path of righteousness. The human condition was seen as eternally weak, and thus stern, if not brutish, measures were required to rescue the immortal soul from possible eternal damnation. The easy readiness to unquestioningly accept that demons were everywhere meant the evidence bar was set very low to initiate legal proceedings. An allegation, no matter how fanciful or improbable, was enough. The accused then had to prove their innocence without even knowing the precise terms of the accusation that any accuser could have made in secret. The Inquisition permitted arbitrary arrest based on untested accusations. The Inquisition was permitted to indefinitely detain and torture an accused person or any other person of interest to the inquisitors. Confessions gained under torture could be accepted as undisputed fact by the Inquisition courts. All these practices were eventually swept away by the legal reforms over more than 300 years between 1500 and the early 1800s. Witch trials. Now, the basis for launching proceedings against men or women for being witches or warlocks relied heavily on untested allegations and, critically, the acceptance of demonic or spectral presence. Just to assert someone was or had been possessed by demons lowered the prosecution evidence bar to a point where just about anyone could be accused, and of course conviction rates were very high. It took the early stages of the Enlightenment and scientific reasoning and the more evidence-based approach to religious law as practiced by the Protestants that senior law officers began to ask the obvious question. To accuse someone of demonic possession, and even the issue of the spectral presence itself, required the devil be available for cross-examination, or at the very least be available for a chat with the state prosecutors. As the devil was not ever going to be available for questioning, it therefore followed alleged demonic congress could not be proven beyond a reasonable doubt. Today, this seems like an obvious point over a patently absurd ancient practice, but take out the vague asserting of a spectral presence combined with the reversed burden of proof and substitute modern terms of denunciation, such as fascist, racist, bigot or sexually inappropriate behaviour, and you can see how close the Western jurisprudence of today may be coming to relive the madness of the past. The hashtag #MeToo is a useful modern day example. Without evidence or trial, the lives, reputations and careers of men are and have been ruined. Now, think carefully here. Do you want your accusers to lynch mob you from the nearest tree without evidence or proof? Or should they have to front a court of law with evidence that must be tested by due legal process for its veracity? McCarthyism. Amidst the genuine concern about Soviet-Russian espionage and infiltration of agitators and activists, the US Congress created the Committee for Un-American Activities, or HUA. The committee had powers of subpoena to compel citizens to appear before it. Added to this were powers of detention by use of the technicality of contempt of Congress. As the alleged crime, if it could even be called that, was to have been or currently be to have known or associated with a communist, the bar of evidence for serving a summons was very low. Moreover, the committee could ignore freedom of speech and associated articles of the Constitution by citing the greater alleged imperative of national emergency and the sovereign powers of Congress. Further, should any of those dragged before the committee take the fifth to avoid any self-incrimination, they were then compelled to name others, and if they refused, then were held in contempt and ran the risk of imprisonment. Those summons to appear were publicly defamed and accused often on unproven and even fanciful allegations, but they had no right to examine or test the evidence or accusations being used against them. As the evidence bar was so low and thus the accusatory procedures so sloppy, many innocent people were destroyed along with the guilty. Even to be accused could result in loss of one's job, and those trying to clear their name through the courts often bankrupted themselves in the process. Many ended up taking their own lives. As communist sympathisers were heavily overrepresented amongst the Hollywood movie community, teaching and academia, unions and the homosexual lesbian community, the era of McCarthyism has left an indelible stamp of bitterness and spiteful smarting amidst the same community that even today remembers this almost 70 years later. Those who do not understand or learn from the past are doomed to repeat the mistakes of the past, often to bitter and lasting effect. Globalist law is political law, and its primary purpose is to positively propagandise globalist policies and also to shut down any of those who dissent from or may disagree with the globalist narrative. As a leading Marxist propagandist rated, it is better that 10 innocent men go to prison than one guilty one go free. I could not find a single law graduate or student who disagrees with this chilling assertion, an assertion that could overturn almost 3,000 years of jurisprudential evolution. What we learn from history is that we learn nothing from history. You've been with Tacitus Today, and thank you for listening.